My column this quarter for InsideTrack, the online publication of Wisconsin Bar Association, is on one of the most difficult issues I've faced as a family law attorney, which is the right of children to have their voices heard in the family court setting, how it's done, when it's done, and how to do it in a way that promotes the interests of children rather than harming them. In Wisconsin, there is no, quote, magic age like there is in certain states. Certain states say at a certain age children have a right to be heard. Wisconsin doesn't have that. In addition, our form of child representation is through a guardian ad litem who represents the best interests of a child. Guardian ad litem is not the child's advocate, and by case law, it is expressly prohibited for children to have an advocate in court. In a lot of cases, this really doesn't matter because a child is too young to express his or her opinion. No one's going to ask a 6-year-old which parent he or she wants to live with. And in a surprising number of cases in which I've been involved as guardian ad litem, it's a non-issue because children don't want to have a say. They don't want to choose between their parents. Or as an 8-year-old girl once said to me without being asked, she said, "Why is everybody asking me who I want to live with? I think adults should make that decision, and I'm just a kid." I thought that was one of the wisest and most mature thing that's ever been said in my office. And there are a lot of kids, even through their teenage years, who do not want to be put in the position of having to choose between parents. Still, where it becomes difficult is when you're dealing with teenage children, especially children at an age where they want to have a say, and if they don't have a say, they may act out in a certain way, even voting with their feet, or 16 and above, voting with their cars. And there's no really express answer in terms of how that's dealt with. The guardian ad litem under Wisconsin statutes is responsible for communicating to the court the wishes of the child, unless the guardian thinks it wouldn't be in the child's best interest to do so. And sometimes the child says, I don't want to choose between my parents, and it's easy to communicate that to the court. It's where the child does express a preference and where the child is at an age and maturity level where that presence maybe should be expressed in some means or another. In other states, it is fairly commonplace for children to actually come to court and talk to the judge, usually not in a formal courtroom setting, but sometimes in a judge's chambers. We almost never do that in Wisconsin, and I think that's a good thing. I don't think children need to go through the experience of coming to a court. That's intimidating enough for adults. I think it'd be even more intimidating for children. But I think the guardian has a right, an obligation to bring that out. And depending on the age and maturity level, sometimes it needs to be expressed. There are children who should know that they have a right to have what they think, what they believe, and what they say become part and an answer of what happens to them. Part of that reason is because if they don't have that expressed in some means or fashion, they may very well act out. The most common, of course, is a 16-year-old child with a car who is going to go wherever that 16 or 17-year-old wants to be, wants to go. And the court system, although legally having jurisdiction to order placement up to age 18, in real life, it just doesn't happen. The child is going to go wherever she wants to, and the court is not going to be able to order anything different. That's not necessarily a good thing, because it can lead to manipulation. There are cases where parents offer certain incentives for a child to spend more time with them. Those incentives can be in form of allowances, cars, or lack of rules and lack of responsibility. And that's not good for children either. And it's a very, very tough decision in terms of when a child should have his or her wishes expressed to the court and how should that be done. part of guardian ad litem training should be in how to talk to children, because it's not something that's intuitive, just because a guardian ad litem may have had his or her own children, that's different from children whose parents are divorcing. And there's certain aspects in terms of how to relate to children, how to talk to children about these issues, and then how those issues should be relayed to the court, and then how the child should be informed that their issues are being related to the court. The toughest ages in this are between the ages of about 10 and 16. As I said, below 10, most people, it isn't going to matter what the court, what the child says or wants. They're too young to express a wish. 16 and 17, they're going to pretty much vote with their feet or with their car, as I said. It's that in-between age where it becomes very, very difficult. And when I've done guardian ad litem training, I've asked lawyers who are training in this field to remember the part of the Hippocratic Oath which doctors take, which goes, above all, do no harm. When you serve as guardian ad litem, the goal should be to help these children out. And especially in these cases where what happens to these kids can affect them, not just through their minority, but can affect their relationship with their parents for many, many years to come, especially if it's a child who doesn't like to hear that some parent isn't listening, doesn't respect them, and doesn't care what they want. So I encourage anyone serving in the role as guardian ad litem to attend courses, read books, talk to psychologists, and where possible, try to get mental health professionals involved. And this is an area where a mental health professional, social worker, psychologist, who specializes, is trained, and has had experience in dealing with adolescents through divorce can be a great deal of help, both for the guardian ad litem and for the parents. So if there is one of these situations that are difficult, I don't think it's within the field of the practice of law or within the intuitive nature of people just because we have parents. It's an area where we need to seek outside help, and that outside help should be with somebody with degree, training, and experience in child development, and as child development is affected by marriages which are ending.